You may be preparing for a deposition and maybe even be a little bit nervous, but I'm going to tell you right now what to expect and how to get ready for that deposition, whether it's tomorrow, a week from now, or even a month from now. I'm Derrick. I'm a personal injury lawyer in Simpsonville, South Carolina, and I've sat through well over 500 of these things. So I'm going to do my best today to get you ready for your deposition and explain exactly what to expect. So one of the very first things that people wonder is, why in the heck is this lawyer going to depose me? Why do they want to depose me? This is their only opportunity to get your side of the story, or for them to ask you any questions before trial. I like to tell people there's kind of three important reasons they're looking here. They're looking to find out what your story is and what you will tell a jury. They're trying to pin down your testimony to make sure they know if you're going to say that their client was going 55 or 105. And they're also trying to potentially try and trip you up, if they can, on any kind of misstatement or story that you might tell about the situation. Something I want you to remember is that you are going to be nervous. Whenever the day comes, if it's tomorrow or a month from now, you're going to be nervous, and it's okay to be nervous. Similar to being right before a sporting event or something like a competition, you're going to be nervous. I'm nervous. I've done hundreds of these things, and I'm nervous before every one of them, and I'm not the one that's getting asked any questions. So I don't want you to be overwhelmed by your nerves or to think that something's wrong if you are nervous when you wake up, or if you're nervous when you try to go to sleep the night before. It's okay to be nervous. But that's why we're here. That's why we're going to talk through this, and that's why we're going to cover all the things we expect, so that if you are nervous, you know that you're ready. All right, so generally in a personal injury deposition, so that's what we're going to be talking about, full tilt boogie here. In a personal injury deposition, if you're the plaintiff in a personal injury case, typically the questions that the other side is going to ask you are going to kind of be broken down into four particular areas. The first area is a lot of background. And these are questions that sometimes folks are like, why in the heck are you asking me these questions? They're questions like, what church do you go to? What club, organization are you a part of? Where'd you go to high school? These are things that people that have really nothing to do about the case, but they're questions that people get aggravated about because they feel like they're coming out of left field. The reason why they're asking these background questions, and the reason why these are important, is because the other side, we ask these questions too, but the other side wants to make sure that there's nobody on that jury, potentially, that knows you or has reason to believe or think that you're telling the truth more than the average human. So if you're a member of the Shriners, they want to make sure that they don't have any Shriners up there if they can. Or if your last name is, Washkowski, they want to make sure there's no Washkowskis up on the jury pool, right? They want to make sure that everybody up there is indifferent to you as a human and won't believe you any more than anything else. So that's why they're asking all these really random questions. The other three parts are really about the case in particular. So in an injury case, oftentimes they'll go background, and then they'll talk about the incident. So if it's a car crash case, they want to know about the crash. If it's a slip and fall, they want to know about the slip and fall. And so they will oftentimes go into those facts second. This is just kind of generally speaking. They don't always do it this way. And then they go into your treatment, your injuries, and the impact on your life, or the impact that the injuries have had on your life. And so there's generally those are the four major signposts that you have to think about as you're going and getting ready for your deposition. And thinking about them as they're asking questions, you can probably think, okay, this is a background question, or this isn't an incident question, or this is a treatment question. Thinking about those and how those things fit together as you're getting asked the questions, I think is beneficial. The next piece that I want you to think about is your approach to the other lawyer. The other lawyer may be kind. They also may be a jerk. I want you to think of the other lawyer in a similar way as when you met your spouse's parents for the very first time. You gave them a little bit of deference, right? If they said something that was a little off color, you probably took it in and just kind of nodded your head. I want you to have that kind of deference, that kind of politeness that you had on that very first meeting. Now, some of that waned as you got to know them, I'm sure. If you are a no ma'am, yes, sir kind of person, I want you to say, no, ma'am, yes, sir. If you're not, don't overdo it. Depositions are not a race. They're not a marathon. So you can take breaks whenever you want. And if you take a break for 30 minutes, the court reporter doesn't write down 30-minute break. It's just, we go off the record, come back on the record. So if you get upset, or if you have to use the bathroom, or if you need to call daycare to make sure your kid's okay, or take a smoke break, right? Everything like that is okay. Nobody gets upset. I'm usually the first person to take a break because I got to go to the bathroom. The record doesn't reflect any kind of reason or anything. It's just a break and you move on. So feel free to do that. Getting to kind of the golden rules of your deposition. The very first kind of golden rule is to tell the truth. This seems obvious. Okay, it seems very obvious that of course I'm going to tell the truth. Truth is the thing. Telling the truth in a deposition sometimes means saying, I don't know. If you're not, 98% sure that something is correct, you don't have to say that you're certain of it. Okay, so this truthfulness, I want you to be truthful, but I also want you to make sure you're not being certain of something that you're not certain. And so that leads us into kind of one of the next important golden rules is that if you don't know or don't remember, you say so. Your whole deposition can't be, I don't remember, okay? But if there is something that you are uncertain of, you don't have to be certain. You don't have to make the statement as if you are 100% certain that you're absolute. You can say, the best that I remember, I think this, or the best that I remember, I think the next provider I went to was the urgent care on Wade Hampton Boulevard. You don't have to be, I went here and this is the fact and that's it. You don't have to do that. The next golden rule is to listen to the question. And this is another one of those ones that kind of seems obvious. Of course I'm going to listen to the question. But a lot of times in conversation, there's a lot of overlap between you know what the person is going to say, and you start to talk or give that response as they're finishing their sentence. You can't do that in a deposition. Number one, the court reporter gets screwed up because she needs a clean record and she's trying to figure out, okay, what did Ann say and what did Bob say and all this stuff. Number one, you want to keep a clean record. And number two, you want to make sure you know the answer before you answer the question, right? And if you're not sure of the question, or if you start to answer before the question has been finished, then you might answer incorrectly. The rule is let the question kind of wash over you. Some people say that you should ask the question internally of yourself also afterwards and then answer. I don't think that necessarily needs to be the case, but I want you to listen, pause, and then answer. The next kind of big golden rule is to only answer what's asked. If I ran into you at Walgreens and I thought that you were going to go to the library today, and I walked up to you and asked you, did you go to the library today? Your response might be, well, I couldn't go to the library today. My mama got sick. So I had to go pick her up from work because she can't drive. So I picked her up from work and we went over to her primary care physician and we went there and they wouldn't see her. So I had to take her to urgent care over on Pelham and they saw her, they prescribed some medication and I went to Howard's. Howard's didn't have the medication. So I had to sit there, but I waited there for about an hour. And then I finally made it to Walgreens. And so I didn't really get a chance to go to the library today. That is what we normally would do in a conversation with somebody that we knew or saw at Walgreens. But the answer in your deposition, if somebody asks you if you went to the library today, the answer is no. It's not the long-winded thing. Then you allow them the opportunity to ask you about where you did go. That is, of course, a very long-winded explanation of just answer the question that's asked. Your deposition is not your opportunity to tell them your whole story. It's not the time for you to vindicate what happened. It's not the time for you to justify anything. It's the time for them to ask you questions that they want to know the answer to. That's it. The last golden rule is it's okay to take your time. It's okay to think about your answer. It's okay to kind of think this is right. Let me and talk through it. Next thing are some traps or things to watch out for. One of the big things that will happen a lot of times is the other lawyer will try to put words in your mouth. So they might ask you something like, is it fair to say that blah, 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 blah. If it's not fair to say that, it's okay to say no. Don't let them put any words in your mouth. It's perfectly okay to say, No, I don't agree with that statement. If they rephrase something that you already said, make sure it's exactly what you already said. Stay away from absolutes. Stay away from never or always. I hear a lot of folks say, well, I always tell the truth, or I never do that. Stay away from that. We say that kind of stuff in normal conversation with folks, but you don't want to say that in a deposition. You only want to be talking about things that the facts and the situations of that particular case. If you say never or always, it always is bigger than the actual fact. This goes back to that deference that I was telling you about with the opposing counsel, similar to your spouses, your in-laws. Don't argue. When your deposition is over, the number one thing that is going to happen is they are going to write a report to the insurance company about your deposition. Probably the very first paragraph is going to be about you as a human, and whether or not 12 people in the particular county where this case was filed is going to like you. If you are argumentative, if you are rude, if you are disheveled, if you are easily agitated or aggravated or a jerk, they're going to write that. And that is going to directly impact your case, which kind of leads me to the next thing. So a lot of people want to know, how am I supposed to dress? What am I supposed to look like? I kind of have the same general rule that we talked about with the in-laws. What I want you to do is dress like you're going to church, but just not Easter Sunday. You don't want to have your top hat, your pastel, your big shoes, your big hat, anything crazy. You want to have it just a normal Sunday visit to your church. If you're not a suit guy, don't wear a suit. If you are a suit guy, wear a suit. So when they look at you and they see you and they judge you, because they are going to be judging you the whole time, you are putting your best foot forward. The same thing you would do when you met your in-laws for the first time. You probably dress a little bit nicer than you would every day. And that's the kind of way I want you to approach your deposition. The last thing that I want you to be thinking about for your deposition in a personal injury case, how the injury has impacted your life. And not by saying something like, well, I'm going to give you that example of CVS again. If I were to walk up to you and I knew that you were in a car crash, and I asked you how you were doing, most of the time people say, I've just been fighting. I'm doing better. I'm doing all right. You might tell them you finished treatment, but things are going great. We want to be the hero of our own story. We want to tell people that we are surviving and thriving, even in the face of crap. But in your deposition, it's vitally important that you tell the other side exactly what the heck is going on with you. If you have to sleep in a recliner because your shoulder is screwed up, you got to tell them that. If your husband had to help you to the bathroom and he had to be the one to be there to help you to wipe and get back into bed, you tell him about that. You wouldn't tell the deacon of your church that if he's asking how you're doing at Walgreens, but you darn better tell them tomorrow or whenever your deposition is. So I want you to be thinking about examples in your life that show and can tell a story about what's been going on. If you run races and you still run races, but you hurt, you gotta, ice yourself for 3 hours afterwards, tell them that. If you have to hire someone to come in to do your housework, tell them that. Or if you're still doing your housework, but it hurts like hell, tell them that. Do not gloss over that. Your testimony about the injuries impacting your life is something that only you and the people that are really close to you will know. That stuff is not going to be in your medical records. It's not going to be a direct reflection of your total bills. It's not going to be in the accident report. Now, there might be some stuff in your records about talking about, activities of daily living and blah, blah, blah. But the stories about how this is impacting you or your family are not there. And it's going to be up to you to tell that story when the other lawyer asks you, so how's this impacting your life? The answer to that question can't be, it's been terrible. You have to give them concrete examples about what has happened to you. You've got to be detailed, give examples. That's the only way they're going to know. Drawing all of this together for you, like 3 big things, right? Being polite, giving them some deference. And the third thing would be to answer briefly and answer only the questions that are asked of you. If you're my client, we're probably going to send you some emails and some documents that you can review, some example questions, things like that. If not, if you have any questions about something like this, feel free to shoot me an email. I'll be glad to answer. If you're overwhelmed, if you're so scared you can't stand it, I'm always here to help. If you need some help through your deposition or whatever, let us know. Again, I'm Derrick. I'm a personal injury lawyer in Simpsonville, South Carolina, and been doing this a long time and sat through hundreds and hundreds of these things. And so if you have any questions or got anything that you want to know about it, feel free to shoot us a question. All right. Thank you.